Hello, everyone. I think we'll go ahead and get started. There might be a couple others coming in, but I think we want to get right down to it today. Before I get started, just a couple of reminders. If you have a cell phone or something that makes noise, if you would put that on silent, please. Also, Fairhaven asks that you wear a mask in the common areas. You can remove them here if you'd like in Fellowship Hall, but in the common areas, if you would please use those. Maybe next semester that'll be a thing of the past. Wouldn't that be nice? So anyway, with those two reminders, let's go ahead and get started. My name is Carrie Bourne. I work for the Office of Continuing Education at UW Whitewater, and we host the Fairhaven Lecture Series here at Fairhaven Senior Services. Next year, we'll celebrate 40 years of doing that, so we're very proud of our partnership here with Fairhaven Senior Services. This semester, we've been rediscovering Wisconsin and some of the people and events that have shaped our state, and today we'll get to hear about Wisconsin's first female lawyer, from Jennifer Mottzko. She is the head of archives at UW Whitewater. She holds a BA in history from the University of Wisconsin-Madison and has master's degrees in history and library information science from the University of Wisconsin-Milwaukee. Jennifer has over 14 years of experience working in both corporate and academic archives. She began her archival career with the Harley-Davidson Motor Company as a museum technician, but spent over 10 years as a manuscript archivist for the University of North Carolina at Greensboro. In 2018, she moved back to Wisconsin to head the Archives and Area Research Center at UW Whitewater, where she manages university records, genealogical resources, and manuscript collections that document the agricultural, business, and supernatural history of southeastern Wisconsin. Please welcome Jennifer Mottzko.
Thank you. I'm beginning to think I shouldn't have written such a long bio. Thanks for having me here today. I'm going to spend some time talking about Lavinia Goodall, who was the first female lawyer granted admission into the Wisconsin State Bar. She spent most of her life fighting for women's rights, both her own rights and those of other women she represented in court. So let's start at the beginning. Rhoda Lavinia Goodall was born in Utica, New York in 1839 to William and Clarissa Goodall. Mr. Goodall was a merchant trader who took up the cause of abolition and temperance, so against anti-slavery and anti-alcohol. During Lavinia's childhood, he moved the family to Brooklyn, New York, where he built a national reputation by writing and publishing reform and anti-slavery newspapers. This is Lavinia and her sister, Maria Goodall Frost. Where did it go? Okay. Lavinia had one sibling, a sister, Maria, who was 12 years her senior. When Lavinia was 11 years old, Maria married and moved away, but the two corresponded regularly. Surviving letters give a glimpse into Lavinia's thoughts and feelings about everything from everyday events to plans for her future. At age 19, as she prepared to graduate from Brooklyn Heights Seminary, Lavinia first mentions wanting to study law. She writes, "Dear sister, you know I expect to graduate, and I must have some life plan. I don't believe in living to get married. This would be different if women would learn to depend more on themselves instead of thinking it devolves on the other sex to support them." She goes on to say, "I think the study of law would be pleasant, but the practice attended with many embarrassments. Indeed, I fear it would be utterly unpracticable. Our folks would not hear to my going to college. I should not mention it. Mama is afraid I shall become identified with the women's rights movement. In all probability, I must teach. That is about all a woman can do, and now the profession is overcrowded with women." Yeah, there are a lot of great quotes coming from the mouths of the people who lived this. But her parents didn't want Lavinia to leave home, the youngest child, unmarried daughter, and the law would have to wait. As she told Maria, "I shall wait 8 or 10 years before deciding and see how matters stand." Yeah. Lavinia was with her family in New York during the Civil War. She aided her father at his anti-slavery newspaper, the Principia, even sitting in as editor-in-chief while he was ill. After the war, Lavinia's parents moved to Lebanon, Connecticut with Maria and her family. Lavinia stayed behind and took up a career in teaching at the home of a Brooklyn merchant. She and her sister corresponded frequently about the trials of teaching ill-behaved children and dealing with their parents, not unlike today. In 1866, Lavinia became ill and took a leave of absence from teaching. And after teaching, she went back to a profession she had already tried. In 1867, she started work for Harper's Bazaar. She stayed with her Aunt Mira and Uncle Hill in Greenpoint, New York. And at Harper's, she was paid $624 a year, where she worked to recommend which stories to reprint from other publications. So she went through other newspapers, clipped clippings, and shared that to be reprinted. While Lavinia remained in New York, Maria and family moved to Janesville, Wisconsin. Lavinia was paid well enough to be able to visit during 1868. Here she is in 1870. I have to say this is probably the best picture of her. In 1870, Lavinia's parents moved to Janesville to be with Maria's family, and a year later, Lavinia, aged 32, made the trek to the Midwest to settle into her parents' home. Her father was nearly 80, and Clarissa had health problems. During her first year in Wisconsin, Lavinia spent time integrating into the community, making acquaintances, and becoming involved with the local temperance movement. In January 1872, Lavinia began to study law. At this time, few law schools existed in the United States, and those wishing to become lawyers often apprenticed with local attorneys. Lavinia, as a woman, was turned down by most of the dozen lawyers in Janesville, but A.A. Jackson agreed to direct her studies, which she did at home for 5 or 6 hours a day. Here are some of the law books that she read. Commentaries on the Laws of England by William Blackstone, A Popular and Practical Introduction to Law Studies by Samuel Warren, and Treatise on the Law of Evidence by March Phillips. In March of that year, Lavinia writes to Maria telling her that she has been studying law for 6 weeks and liked it ever so much. She goes on to say, quote, "I don't like to tell what great things I'm going to do, but wait and see whether I can do them. I think the information I shall acquire will always be of great use to me, even if I never should practice. If I succeed in getting credibly through my studies, though, I think I shall try to get admitted to the bar, if only for the precedent. How would it look? Lavinia Goodall, counselor at law." By early 1873, Lavinia reports that she is reading, quote, "no books now but law books." She regularly attended the Rock County Circuit Court, where she would watch the presentations of the lawyers and Judge Harmon Conger. She told Maria that it was quite an innovation for her to go into court because Janesville was such a, quote, "small, conservative, and gossipy town." Throughout this time, Lavinia continued to try to get an apprenticeship with an attorney without success. She had private tutelage from 2 unidentified lawyers who would sometimes hire her for copy work, but would let her go if a gentleman came along to fill the position. By June 1874, Lavinia was prepared to be examined for the bar in Rock County. So she'd just been reading law for a very short period of time. However, when the time came to go before a panel of local attorneys and Judge Conger, she was told by Conger that lawyers were busy trying a case and, quote, "cannot attend to it." She learned from another lawyer that the judge intended to refuse her admission because she was a woman. Lavinia prepared for the fight. She wrote to the suffragist Lucy Stone and several other women lawyers across the United States. She compiled a list of judges who had permitted women to be examined for the bar, as well as legislation that allowed women to be admitted to the bar. Finally, within the next few weeks, she was permitted to be examined along with 2 other gentlemen from Beloit. And she describes them as nervous gentlemen. And she prepared to, quote, "study up and come down on him with what thunder I can command." On June 18th, Lavinia wrote to her cousin, Sarah Thomas, quote, "the middle-aged, gray-headed individual who now addresses you is an honorable member of the Wisconsin bar." This article from the Watertown Republican reads, at Janesville, Wednesday evening, Miss Lavinia Goodall was admitted by Judge Conger to practice law in the courts of the state. This is the first instance in which a female has been recognized in Wisconsin as eligible to the profession of law. Miss Goodall is a daughter of Reverend William Goodall, the champion of abolitionism and temperance. She possesses a pleasing and modest address and sufficient intellectual vigor to rank among the foremost of her profession. Right? She was both nice and good at what she did. Once licensed, Lavinia immediately set up her law practice. She rented rooms near another lawyer, painted and papered, and had business cards printed. Those are over on the right-hand side. Kind of hard to see on this. She also immediately put an ad in the Janesville Gazette where you can see Miss Lavinia Goodall, attorney at law, and that her office is opposite the First National Bank in Janesville. And at the very top is her stationery that she had printed. During her first month of practice, she took on small cases in debt collection and drawing up guardianship papers for clients. In August, she had her first big case. Temperance women from Fort Atkinson wanted to take action against two men for illegal sale of liquor. She wrote to Maria that it was, quote, real fun. I knew just what to do and was not a bit frightened, and do not think now I should be afraid to run any case through court. She won both cases, but the men appealed. She won one of the appeals and lost the other, but was thoroughly delighted to unnerve the opposing counsel, who was, quote, so flustered and nervous and mad that it tickled me immensely. In 1875, the client from this liquor case in Jefferson County appealed to the Wisconsin Supreme Court, where Lavinia prepared to appear. But first, she had to be admitted to the state bar. And one big obstacle stood in her way. And with that cliffhanger, I want to take us to a case that Lavinia was working on at the same time as everything was happening with the Wisconsin Supreme Court case. Hold on to your hats. While Mrs. Goodall's case was being argued in front of the Supreme Court, 1875, she continued to represent clients in their own cases. The Leavenworth versus Leavenworth case would be a long battle for a divorce. On June 23rd, 1873, Elizabeth Leavenworth visited the law office of Wymans, Dixon, and Patton in Janesville to file for divorce against her husband, Ira H. Leavenworth. The two had married in March 4th, 1849. They lived on a farm in the La Prairie Township outside of Janesville for about 8 or 9 years, the last 8 or 9 years of their marriage. Mrs. Leavenworth claimed that during their marriage she had, quote, conducted herself with prudence and propriety and treated her husband with kindness and affection. The couple had one son, Willis, who had died about 11 years before, in 1861, at age 6. After the death of their son, Ira began to treat her unkindly, finding fault and making her miserable. He was often away from home on business, leaving her to care for the farm, and would return home to berate and belittle her. The incident that led her to file for divorce happened on June 21st, while Ira, quote, violently seized her, threw her upon the floor, and pushed her out of the house. And that after he pushed her out of the house, he locked the doors, and she was obliged to go to the neighbors for shelter and protection. She went on to state in her case that she was frightened of returning to home for fear that he would, quote, renew and repeat his cruel and inhuman treatment of her. To add on to that, in her complaint, she says that she has about $300 of cash and a small wardrobe as her property, but that the family farm, cattle, etc., are worth about $6,000 to $8,000. She brings a witness, their neighbor, Mr. Eli Proctor, to say that he heard Mr. Leavenworth threaten to, quote, dispose of and encumber his property, so she would not have any portion of it in alimony if they were granted divorce. The judge granted an injunction that Mr. Leavenworth not dispose of his property in any manner until the court matter was settled. Now, before we go any further into this case, let's back up to talk about women's property rights and the means for divorce in the mid to late 1800s. So in the early 19th century, women few women worked outside the home and had limited control over their own property. In the 1846 Wisconsin Constitutional Convention, they adopted a provision that all property owned and acquired by married women would be their separate property. Opponents argued that not having the wife's property under the husband's control would disrupt existing credit practices where husbands could use their wives' property as collateral for loans. Others, such as Delegate Marshall Strong of Racine, argued that the issue of women's property rights would upset the order of the household, where, quote, woman is to be transferred from her appropriate domestic sphere, taken away from her children, and cast out rudely into the strife and turmoil of the world, there to have her finer sensibilities blunted, the ruling motives of her mind changed, and every trait of loveliness blotted out. The 1846 Constitution was defeated, and when they gathered again in 1847 and 48 for the new convention, many believed that the property rights provision played a role in the demise of the 1846 convention. The second convention left the provision out and left it up to the legislature to decide. So in 1850, the legislature passed a law with the title, quote, concerning the rights of married women, that made property owned by the woman at marriage or acquired after marriage her own separate property, and she could keep or dispose of it without her husband's consent. This law was mostly seen as a way to keep a husband's creditors from seizing the wife's property to satisfy debt. And many court battles over women's property rights waged in the next 20 years. But the law held that Elizabeth was at least entitled to her $300 of cash and her wardrobe. Ira had primary control of any property acquired or purchased during their marriage. And then on to divorce. When Wisconsin became a state, divorce was not easy to obtain. It was allowed for only two reasons: cruel and inhuman treatment or desertion. In the Johnson v. Johnson case of 1855, the courts limited the definition of cruelty to conduct which, quote, endangers the life or health of the wife, which exposes her to intolerable hardship and renders cohabitation unsafe. That could be interpreted in many ways. In addition to cruelty and desertion, the legislature passed a law in 1866, just less than 16 years later, that allowed divorce after a voluntary separation of 5 years, making Wisconsin one of the first states to create a no-fault basis for divorce. However, cruelty was the most common grounds for divorce, and mostly because many Wisconsin judges interpreted the term quite broadly. Waiting 5 years for divorce was also not the best option for women who relied upon the husband's financial support. All right, back to our case at hand. Ira, after this first divorce proceeding began, Ira convinced Elizabeth to return to him. And on July 7th, 1873, her lawyers made a motion to discontinue the action. And the two lived happily ever after. No, of course not. On December 5th, 1873, Elizabeth issues another complaint. So this is like 6 months later. As well, and the complaint also includes his brother David Leavenworth and his wife, and his sister Berzena de Goyler, I can't speak, and her husband. The complaint reads similar to the first, stating that she, quote, treated him with kindness and consideration in all things, behaved herself with propriety, and observed and kept all her marriage vows, faithfully performed all her duties as a wife to the best of her ability. She outlines more abusive acts from her husband going back to October 1862 when he, quote, struck her and knocked her down on the floor. He immediately left for Ohio and was gone until spring, leaving her to reside with relatives. Her complaint reads as a typical spousal abuse. Mr. Leavenworth would return, he'd apologize, promise never to treat her unkindly again. She would take him back till the next time, and then he would leave. She'd come back. Anyway, continuing on for about the last 11 years of their marriage. So, and they had been married 25 years. In addition to the abuse, Mrs. Leavenworth claimed that her husband had disposed of his property to his brother David in order to appear as though he had little or no assets to provide alimony for her support. The case continued on for over 2 years, with over 300 pages of depositions taken by the lawyers for both the plaintiff and the defense. Lavinia joined the case in the summer of 1875, more than 50 pages into the court documents. Mrs. Leavenworth was seeking a divorce on the grounds of cruel and inhuman treatment and wanted alimony to support her. In order to get this, she needed to prove that Mr. Leavenworth had deeded this property to his brother David in order to appear to have no assets. Let's run you through the ins and outs and ups and downs of the case, because it's 2 years. Mrs. Leavenworth claims this abuse and lists several incidences, some of which were witnessed by friends, relatives, hired help at their farm. Abuse for the purpose of divorce needed to be witnessed and sworn to in court. So because the Leavenworths had lived in many different places before settling in Janesville, the lawyers traveled to collect depositions, these sworn statements from witnesses to be used at the trial. Trips were made to Partyville in Columbia County, where Mrs. Leavenworth grew up, met and married Mr. Leavenworth, and where they lived as man and wife for several years. Also, depositions were taken from a former hired girl in Milwaukee and Mr. Leavenworth's relatives in Illinois and Iowa. Returning from one of the depositions, Lavinia wrote, quote, "Last week I went to Columbia County, about 80 miles from here, to attend the taking of some depositions in the new case. Had quite a rich time. The vicious husband was on hand with his lawyer, and I had the pleasure of eliciting considerable unwilling testimony from his witnesses on cross-examination and getting some good testimony from my own. Was quite a lion in those regions. I was quite hard on the bad husband and expected he would be ready to eat me, but we came back to Janesville together, and he was inclined to be quite attentive and devoted. It was very amusing. He actually complimented me on my ability in the management of my case. Perhaps he thinks he can humbug me." Lavinia really believed in helping her clients and strove to find witnesses that would testify on her behalf, as well as spending time interrogating the defense's witness to try to prove that they were lying in this case. While Mrs. Leavenworth claimed 13 instances of abuse in her action, not all were testified to by witnesses. 4 people did witness what I'm calling the potato incident of 1864. I know that it was probably very scary in the moment, but the lengthy testimonies from the witnesses turn it into a farce. According to Mr. Keach's testimony, he was a hired hand at the time, the argument started over a picture. Mrs. Leavenworth and a friend, Mary Ann Farmer, had had their pictures taken the day before, and the Leavenworths began arguing over which was the prettier. Mr. Keach said, quote, "She was peeling a pan of potatoes. He picked up one and threw it at her. It hit the side of the house and busted open. I think she dodged it. She didn't stand still." Mr. Keach said that nothing further happened. Mr. Leavenworth didn't chase her, didn't yell at her, didn't hit her with a stick or a boot. So, cruel and inhuman treatment, she didn't get hit in this instance. Mrs. Knapp, a neighbor, had a different story in her testimony. She said, after the argument over the picture began, he threw a large turnip or potato. Elizabeth darted out the door. He ran after her, then turned back and picked up a stick of wood, threw it down on the floor. I looked at it as perfectly savage. She stayed out of doors until she was nearly froze. Her deposition actually includes a hand-drawn map of where everyone in the house was standing at the time. So it was very serious going back and forth between these two. In September of 1875, as this continues on, Mr. Leavenworth files a counterclaim that Mrs. Leavenworth was abusive to him. He says that, quote, She has been for many years ugly, fretful, fault-finding, petulant, abusive, and aggravating in her language to this defendant. And she has several times during the time they have lived together as husband and wife struck and scratched this defendant, and at one time threw a bucket of swill upon him. The depositions continued through the fall of 1875, with the last opponents being Mr. Leavenworth's brother and his wife, along with Mr. Leavenworth's sister and her husband. These testimonies were mostly in regards to the disposal of the property. Per the land deed filed October 31st, 1873, Mr. Leavenworth sold the farm to his brother and sister-in-law on July 9th, 1873 for $6,500. This was 2 days after Mrs. Leavenworth had ended her first divorce proceedings against her husband. Mr. Leavenworth's brother then sold the property immediately at the same time at the courthouse for the same value. Both Elizabeth and Ira signed the deed, but Mrs. Leavenworth claimed that she did not know the implications of the document that she was signing. Mr. Leavenworth claimed that he was in debt to his brother for over $5,000 and sold the property to him to settle the debt and have enough money to pay off his other debts and buy a small property for him and his wife up in Partyville for $400. So he's claiming he has no money left because he's finally paid off his debts. Many of the depositions were from family and neighbors swearing that they either knew the Leavenworths were indebted or knew that Ira Leavenworth had plenty of money, anywhere from $6,000 to $12,000 of property and other assets. So the case finally came to trial in December 28th of 1875. The Janesville Gazette reported that, quote, there are numerous witnesses in attendance, and the case is exciting considerable interest. Miss Lavinia Goodall and John Winans, Esquire, appear for the plaintiff. That's the first article up there. The case carried over into the new year, and on January 25th, the Gazette reports Miss Lavinia Goodall made the opening address for the plaintiff this morning, in which she reviewed the testimony and cited numerous authorities. The effort of Miss Goodall added, in the estimation of all who heard her, to the flattering reputation she has made for herself as an advocate at the bar. On January 31st, the Gazette reported this has been one of the most hotly contested divorce cases ever tried in this county and has created more interest, consumed more time in its trial, brought on longer and abler arguments than any other suits of its character ever known in the circuit. His Honor Judge Conger decided that there was not sufficient cause for granting the decree and accordingly refused to grant it, much to the disappointment of the plaintiff and her friends. Lavinia was also upset by the verdict. She wrote in her journal that night, quote, finished Leavenworth case and lost it. Am too mad to say anymore. But she did have more to say to her friend Sarah Thomas in a letter dated February 4th, just a few days later. She says, well, we concluded the Leavenworth case Saturday. We made a very strong case of it, and yet in spite of all, Judge Conger refused to grant a divorce, claiming that the treatment of the plaintiff had not been cruel and inhuman, according to his understanding of those words. The decision surprised and outraged every unprejudiced person. Judge Conger is notoriously opposed to divorces and will never grant one when he can help it. Of course, then she gets no alimony, which was the principal part of the contest. She goes on to say, quote, we are awful mad and are going to appeal. Poor Mrs. Leavenworth cried all night Saturday night, and I felt real bad too. I'm happy to state that Judge Conger has taken sick immediately after sending the decision and has been sick ever since. Lavinia traveled out to La Prairie to talk with the neighbors who were, quote, swearing mad and offered to pay the cost of Mrs. Leavenworth's appeal. Upon hearing that they were going to appeal, the, quote, enemy offered to settle and give Mrs. Leavenworth $500 and some real estate worth $300. But she planned to move ahead with the appeal unless they came up with a higher, quote, figure. This is where I'm going to leave this case right at the moment. See, I have to leave everybody in suspense. Then the direction of this letter changes, and Lavinia states that she is waiting for a decision from the Supreme Court in regards to her admittance to the bar and the obstacles standing in her way, namely Chief Justice Edward Ryan. This is where everybody boos, boo. Edward Ryan immigrated to the United States from Ireland in 1830. 5 years later, he became a citizen and a member of the New York Bar. And in 1835, he moved to Chicago and then to Racine and then to Milwaukee, where he practiced law and was involved in politics. He was a delegate at the 1846 Wisconsin Constitutional Convention, where he voted against including women's suffrage and the provision for women's property rights in the state constitution. In 1854, he gave a lecture titled Mrs. Jellyby, using the character from Charles Dickens' Bleak House, a woman who neglects her family to engage in philanthropy and argue for women's rights, as a device to mock, quote, strong-minded women. He argued that both men and women had unique abilities and roles in society. He said that marriage allowed women to, quote, accomplish her social destiny, and that, quote, every position of women in society which essentially severs her from home or gives her functions or interests conflicting with the duties of home or lessens her peculiar adaptation to the refined charities of home is a prostitution of her sex and a heresy to nature. That's what she was going against. Governor William R. Taylor appointed Ryan to fill out the term of Chief Justice Luther Dixon on June 16, 1874, a day before Lavinia was appointed to the Rock County Bar. He was said to have this unyielding view and a hot-headed and petulant temper, so much so that his wife left him in 1872. Normally, attorneys who had been admitted to a circuit court bar were automatically granted admission to the state with very little fuss. But Lavinia was not a man, so she petitioned the court for admittance in the summer of 1875. On December 14, 1875, I.C. Sloan, a prominent Janesville lawyer, presented Lavinia's argument to the Wisconsin Supreme Court. She was not allowed to do so because she had not been admitted to the bar. He made a point of stating for the court record that the argument he read was prepared by Miss Goodall. Lavinia's rationale for being admitted to the bar centered on 3 issues. 1, she demonstrated that state law did not exclude women from admission to the bar. That statute refers to the admission of a person and used male pronouns. However, another statute made it clear that male pronouns in state laws should be interpreted as extending to all citizens, including females. 2, based on an Illinois case, she demonstrated that the Supreme Court had discretion in whom to admit based on what will provide the fair administration of justice. She argued that justice would be better served by the admission of women for several reasons. Number 1 being that, quote, a class wholly unrepresented in courts of justice can never obtain full justice in such courts. And 3, she showed that women had already been admitted to the bar in Iowa, Missouri, Michigan, Maine, the District of Columbia, and federal district courts in Illinois and Iowa. In mid-February 1876, Lavinia received word that the court had denied her petition. So this was just a couple weeks after the Leavenworth case. Chief Justice Ryan wrote the opinion for the court, adding his thoughts on why women were not suited to practice law. You can guess what he said. Quote, the law of nature destines and qualifies the female sex for the bearing and nurture of the children of our race and for the custody of the homes of the world and their maintenance in love and honor. And all lifelong callings of women, inconsistent with these radical and sacred duties of their sex, as is the profession of the law, are departures from the order of nature, and when voluntary, treason against it. There are many employments in life not unfit for female character. The profession of law is surely not one of these. Lavinia immediately moved from fighting the battle in courts to creating legislation that would aid her cause. The bill would prohibit gender-based denial of bar admissions, and the legislature passed that on March 22, 1877. Lavinia wrote to Maria about her victory, relating, quote, "Judge Ryan takes it quite hard that I beat him. One man who argued against my bill used it as an argument that the passage of the bill would probably be a death blow to Judge Ryan, who was in feeble health. They passed it notwithstanding, but he still survives." The law did not automatically admit Lavinia to the bar, but gave her an opportunity to renew her petition when the time came. That opportunity arose in the spring of 1879 when she appealed a guilty verdict for her client, Tom Ingalls, who was accused of stealing clothes from a tailor shop. Goodall argued in the Rock County Court that Ingalls had been too drunk to cut a precise hole in the shop window. But Judge Conger disagreed and sentenced Ingalls to 5 years in prison. On April 22, 1879, I.C. Sloan again presented Lavinia's petition for admittance to the bar. She was ready to face Justice Ryan and wrote her friend Sarah that it would be delicious to make him admit me the way he has acted. On June 18th, she received the court's ruling 4-1 in favor of admitting her to the Wisconsin Supreme Court bar. Justice Ryan was the lone dissenting voice. So she took her appeal to the Supreme Court. This is her certificate admitting her to the Supreme Court bar. Along with her court battles, Lavinia was fighting her own health. In the summer of 1876, after losing both the Leavenworth case and her own fight for admittance into the state bar, she was diagnosed with an ovarian tumor and admitted to her sister that she was in constant pain. In a letter to Sarah, Lavinia talks about the possibility that she might not get better. Quote, "Of course I believe in God, but I have been thinking of Chloe's remarks in Uncle Tom's Cabin that the Lord lets dreadful things happen sometimes." In the late spring of 1877, she underwent an operation, recovering slowly and continuing to work on her legal cases and lobby for temperance issues as her health permitted. In 1878, after her parents had already passed away, she underwent another operation and again went back to her legal practice. On March 11th, 1880, Lavinia learned that she had won the appeal of the Ingalls case in the Supreme Court. And on March 31st, she passed away, 1 month shy of her 41st birthday. She was a trailblazer in her short life, paving the way for other women to enter the profession. A major accomplishment and a small win for women's rights. Thank you.
Okay, we have time for questions. If you'll just raise your hand, I'll come around with the microphone. Yeah.
As I recall, one of the liquor distributors in Janesville is the Goodalls. And what's the relationship of the Ryan name to the world-famous Ryans?
Oh, gosh, that's beyond my scope at this point. I'd have to do a little bit of digging. Sorry.
Other questions? Yeah, okay, I'll come over here.
How many women lawyers are in Wisconsin today, and how many men? What's the ratio?
Oh, I haven't done anything about it at that point in time. I can tell you, or at this point in time, shortly after Lavinia was admitted to the Rock County bar, there were 2 other women lawyers who did pass the bar, and she practiced with one for about a year in 1879. Actually, I don't even think it was a year. It was like 6 months before they couldn't get along and they parted ways. So that's what I knew at that point in time. Yeah, sorry.
What were the lawyer fees back then?
Oh, okay. Yeah. They have a lot of the lawyer fees written down because they also, they paid travel and they paid witness costs. So for each one of these depositions, it was costing the clients roughly $5 to $6, which was a pretty extensive cost at that time, and that probably $3 of that was going to the lawyer. And considering that they were doing like 15, 20 of these depositions, and then on top of that, I'm not sure. I know that she did some pro bono work in this case. She said she would on the appeal. Does anyone want to know what happened to Mrs. Leavenworth? I did a little bit of digging. It's really kind of hard to track them down precisely. She lived up in Partyville and is buried there, died in 1892, and her gravestone says, wife of Ira Leavenworth. I can't find an appeal. I can't find a divorce record, but I can find another marriage record for Ira. And he shows up in Iowa with a wife and a kid in the 1880s. He was 77 and she was 44. So he came out, I guess. But yeah.
Wow.
Yeah.
Other questions? Do you know where her office was in Janesville?
Some in Milwaukee Street? I think it said on one of these.
Oh,
yeah.
Okay, I missed that part. Neat.
Yeah.
Really?
Yeah.
Wow.
There's so much to her story. And so much that's written, and so many of her letters are out there and survive. This is just scratching the surface of the story, giving you a very kind of broad overview. The court case comes from the records that we do have here at the Area Research Center, because we have the Rock County, and we have we have Walworth County, and we have some of the Jefferson County court cases. We don't yet have the one for the liquor case, so I haven't seen that one, but yeah.
So neat. Okay, Jennifer, we'll hang around a little bit if people have other questions about this case or the research center at UW Whitewater.
Oh.
Yes, did I see a hand up here? Somebody? No?
Yeah.
I'm Nancy Kopp
Hey.
from Madison. My colleague Colleen Ball, who you've dealt with,
Yep.
and I several years
I was
ago
going to
got-
mention your
yes,
website.
Several years ago, you were kind enough to scan these things for us, and I brought along, if anybody's interested, I developed a year or so ago the Lavinia Goodall walking tour
Oh.
that has sites in Janesville. A lot of the original buildings are not there anymore, but it pinpoints where the buildings were. So if people are interested in those, they're welcome to pick.
Do it.
Wow, that's incredible. Yes, I'll definitely
Yeah,
pick one for sure.
you ladies did an amazing job creating this website. It's Lavinia Goodall. What is the address again? It's
www.laviniagoodell.com.
yeah,
LaviniaGoodell.com.
laviniagoodell.com. It's got some great blog articles, quotes from. I stole a couple of the pictures you guys had up there, and so much of her life is up there. So.
Wow, that's really cool. I put those on the back table for anyone who's interested. It's a little map brochure kind of thing with some nice photos and stuff. So they're just right there on the back table. Thank you so much for bringing that to us. That's great. And just a couple closing thoughts here really quickly. If you missed any lectures in this series, we do record them all. Naveen helps and does a great job getting our videos of our lectures. You can just Google Fairhaven Lecture Series. You'll get to our website. And we have videos of our lectures not only from this series, but going all the way back as far as 10 years ago. So lots of different really great videos of our lectures. Also, we'll be back here this is our last lecture for the fall series, but we'll be back here the last week in January to get started for spring. We're going to feature new faculty next spring, so a bunch of different topics, not just one theme. But I'll get that information to Brian, and if those of you who don't live in a Fairhaven property, we promote the series through email. So if you're not on our email list and want to be, I can add you to our list in the back. But for now, this has been a really great series, and join me in thanking Jennifer Mottzko and wrapping it up for the fall. Thanks everybody for coming.